Our next speaker will be Professor Dominik Skauradszun, and he will also make a presentation. Just a brief couple of words of presentation of our colleague. Dominik is a professor of civil law, civil procedure, and company law at Fulda University in Germany. He has dedicated much of his research to matters concerning corporate and insolvency law. He has also written on crypto assets under German civil law, and we will hear him today on crypto assets in enforcement and insolvency proceedings. So, Dominik, the floor is yours. Thank you very much.
Dario, many thanks. Good afternoon, everybody here and online. Allow me to start with a shocking statement. Crypto assets are dead. I can at least see you smiling. Indeed, crypto assets are dead. If it turns out to be true that customers of crypto custodians will lose everything, or at least close to everything, if the crypto custodian goes bankrupt. Then there is not really a need to debate at length the interplay between crypto assets and civil law and private international law and supervisory law and so on. Well, then insolvency law is the pivotal player, is the decisive area of law, and maybe spoils the party and rains on our parade. So let's think about insolvency law, and I tell you, it's not that simple. Luckily, and this is quite reassuring, that the two Portuguese authors, de Macedo and Coelho, have most recently published on those questions pointing to the interplay of crypto assets and insolvency law. So obviously we are all in the same boat. And these questions are merely the next logical step. The more people investing in crypto assets, it is just a matter of time to speak about either the investing party or the issuer or a crypto custodian facing financial distress. It is just the next logical step. And then they all raise the same questions, especially from the creditor's point of view. Well, which enforcement measures are possible? Is it possible to seize crypto assets? Is it possible from the legal point of view to realize them and to exchange them into legal tender? And in terms of insolvency, do crypto assets form part of the insolvency estate, and so on? So at the moment, there is no EU law explicitly designed for the interplay between crypto assets and enforcement law and insolvency law. First EU law explicitly pointing to this interplay will most likely the MiCAR, so the regulation on markets in crypto assets, since the Council has proposed amendments to Articles 42 and 67, so two comprehensive articles dealing with the interplay of crypto assets in insolvency matters, in insolvency situations. But at the moment, again, we do not have harmonized EU law explicitly designed for this interplay. But at least in terms of harmonized EU law, we do have the Brussels I regulation, so a regulation designed for questions about the international jurisdiction of courts, recognition and enforcement of judgments in civil and commercial matters. We do have a European insolvency regulation, and we do have the fifth anti-money laundering directive, at least defining cryptocurrencies and showing us the understanding of the European legislator. At the moment, from the insolvency law perspective, the enforcement law perspective, we are facing two different main scenarios. The first is a debtor, and this debtor has obligations, financial obligations, vis-à-vis 1, 2, 3 or more creditors, and does not pay, does not perform. And then the creditors start thinking about compulsory enforcement, and they are aware of blockchain-related assets, crypto assets. And I symbolize the debtor's assets by using this money bag, and the peculiarity is that subject to the money bag is a blockchain-related asset, crypto assets, whatever they are. And then those creditors will start thinking about state-assisted compulsory enforcement actions against the debtor and raise all these questions whether this is really possible from the enforcement law's perspective. The second scenario is an issuer, and this issuer has launched an offering of security token or investment token and promised the customers, the investors, to repay the investment at a later time and typically to pay interest. Unfortunately, the issuer is unable to fulfill all these obligations, and then the investors will try to push the issuer to file for insolvency, and then an insolvency administrator will deal with all these investors, and the investors will raise the question, what exactly is the rank, the insolvency ranking of my claim? What is it, what I will get finally and eventually when closing the company, when winding up the company? And this second scenario resembles the situation I started my presentation with. So if the crypto custodian is facing financial troubles, then the customers will also raise the question, what is the intrinsic value of my claim? What is the insolvency rank of my claim against the crypto custodian? So this situation is pretty similar. Well, first step, if we understand blockchain-related assets as assets based on the distributed ledger technology and therefore in most cases spread around the world, then it is fair enough to say that those cases are cross-border cases and allow to think about the European insolvency regulation. And the first principle is that we have to check whether the debtor, either a natural person, a legal person, a company, a crypto custodian, an issuer, that doesn't matter, where the debtor has its center of main interests. I abridge this as COMI. So, and the member state of the European Union in which the debtor's COMI is situated has exclusive international jurisdiction to open insolvency proceedings over the assets of this debtor. First principle. And this member state, and this is a huge advantage of the European insolvency regulation, this member state will automatically determine the applicable law. And this is not only true for the applicable law with respect to the proceeding itself, but also with regard to the question whether crypto assets form part of the insolvency estate. And this is obviously a decisive question. So once again, the member state with the exclusive international jurisdiction according to Article 3 of the EIR automatically determines the applicable law, especially regarding the decisive question whether crypto assets form part of the insolvency estate. I give you an example. Let's put the commis of a debtor in Lisbon. So it's a debtor with its center of main interests situated in Lisbon. Then the Portuguese courts will have exclusively international jurisdiction to open insolvency proceedings over the assets of this debtor. And this has influence to the applicable law. So the Portuguese member state of the European Union will automatically determine the applicable law, which means Portuguese insolvency law will apply on the case. Since the European insolvency regulation is based on the principle of universality, this Portuguese proceeding will automatically cover all assets situated in Europe, so far beyond borders. And if we understand the principle of universality in its original sense, then this Portuguese proceeding will also cover assets spread around the world, the universal scope. So it doesn't matter whether the Portuguese debtor has crypto assets or wallets in another member state, in Spain, in France, in Germany. The Portuguese proceeding will cover all of them, but only if the Portuguese law determines crypto assets as part of the insolvency estate. And I guess, asking the audience here or online, what do you think? Do you think it's fair that crypto assets form part of the insolvency estate? We will get a 100% consent, at least if you're thinking about the creditor's perspective, and then you will argue, sure, everything belonging to the debtor should form part of the insolvency estate. And indeed, this is at least the principle in many member states. And besides Portugal, I name Spain, Greece, and Germany. They all have a provision pretty similar to the principle I already raised. Everything belonging to the debtor, all assets belonging to the debtor form part of the insolvency estate. This is the principle. But unfortunately, those member states have another provision saying that assets must be subject to compulsory enforcement, and if not, those assets are excluded from the insolvency estate. And now you understand why the conference has designed the title of the presentation with two areas of law, enforcement law and insolvency law, because enforcement law and insolvency law is strongly intertwined. So we have to check whether national enforcement law allows enforcement actions with a target to seize crypto assets. And that's not a no-brainer. I tell you why. Mostly, a member state, in terms of national enforcement law, differentiates between enforcement actions against movable and immovable assets. And again, we only have to do this to figure out whether crypto assets form part of the insolvency estate. And I guess that most of you will say, well, compulsory enforcement actions against immovable property is obviously not suitable when thinking about enforcement actions against crypto assets. The enforcement in terms of a land, a real estate, is obviously something different compared to crypto assets. Regarding movable assets, it's not that simple. So I guess you all agree that a court bailiff cannot seize a blockchain-related asset. This is possible for a car or a desk or a machine, but not for crypto assets. But in terms of claims, the problems magnify. At least I think you all agree that cryptocurrencies do not give rise to claims, since the users of those blockchain networks do not enter the network with the legal intention to be bound by contracts. And if there is no contractual relationship, then there is obviously no claim. But those member states having a provision, I would call it a catch-all provision or a general clause, allowing compulsory enforcement against other property right. So if you do have a provision broad enough to cover those other rights, then it's fair to say that national law will allow enforcement actions and subsequently allow to understand those crypto assets as subject to the insolvency estate. Back to my example. So a debtor with its center of main interests in Portugal. You will think about debtors with, let's say, a wallet in another member state of the European Union. Let's say a crypto custodian or another institute organizing the wallet, let's say in France. Normally, the insolvency practitioner works within borders and therefore on Portuguese territory. But here, based on the European insolvency regulation, we allow the Portuguese insolvency practitioner to exercise all rights the Portuguese substantive law grants to this very person, and now the insolvency practitioner can exercise those rights in all member states of the European Union and therefore easily contact, let's say, the wallet provider, the crypto custodian in France, and instruct this custodian to transfer crypto assets, for instance. And national law, and this is for instance true for the Portuguese insolvency code, normally forces the debtor to cooperate and to tell the insolvency practitioner the content of the private key, for instance, or the precise crypto custodian. And sure, I'm totally aware of the practical issue that in many cases of an insolvency proceeding, the debtor claims to have forgotten the private key. So I'm aware of this practical issue. Back to the insolvency practitioner, maybe a Portuguese or a German insolvency practitioner. Once the insolvency practitioner has discovered the crypto assets and obtains the private key, then the insolvency practitioner can realize crypto assets and exchange them into legal tender. And I know it for sure that most of the insolvency practitioners do not have experience with exchanging crypto assets into legal tender, but they at least can hire traders specializing in crypto exchange and therefore helping them to realize those assets. My brief last chapter will point to the creditor rights, because some of you will advise creditors or work in research on creditor rights, and I thought I should mention that we see in the market a typical clause in many situations. An issuer has launched assets, investment tokens, security tokens. Then the two contractual parties agree on a special clause, and you may immediately jump to the bold letters, agreeing to a subordination of the claims. So this is what we see a lot. The issuer says, I'm only willing to launch this token if you agree to a subordination of your claim in the event of my insolvency proceeding, which means in the event of the issuer's insolvency proceeding, the customers are ranked as low as possible and therefore will most likely default and can write off their claims. And lastly, as I mentioned, this shocking news from the Financial Times at the very beginning of my presentation. In terms of crypto custodians, we are at the moment trying to understand the insolvency rank of customers. And at least from the German point of view, this is an unsolved question. There is neither any court decision dealing with this question or comprehensive research published by German scholars. But it is at least debatable that the shocking news we saw from the United States could not be the right answer. If crypto custodians can clearly split assets and make clear which assets belong to the customers and that these assets are not mixed up with own assets of the crypto custodians. It is really debatable to understand the custodians as a group of creditors who can claim the segregation and therefore want the insolvency practitioner to transfer their crypto assets to new wallets, to new public keys. Then crypto assets are not dead. So the take-home lessons are, please be aware in terms of enforcement and insolvency law about two regulations, the Brussels I regulation and the European Insolvency regulation. Please keep in mind that the European Insolvency regulation helps at least in terms of international jurisdiction and the applicable law. And please understand that one proceeding opened by a European court will automatically has a universal scope and cover all assets situated around the world. And please have in mind that in terms of investment token or security token, we see a typical clause in those white papers agreeing to a subordination, which means that customers indeed will lose everything in the event of the issuer's insolvency. Many thanks.
Thank you, Professor.